Welcome back to the channel and brace yourselves, because today's courtroom showdown is one for the books. Judge versus defendant, and it's not your ordinary day in court. Meet Miss Salaston, a self-proclaimed legal expert who believes the Constitution puts her above the law. But the judge? He's heard it all before 40 years of what he calls nonsense legal claims. From bench warrants to new Georgia State Patrol arrests, this case spirals into pure legal chaos. Was Miss Salaston wrongfully defiant or just dangerously misinformed? Stick around, because what unfolds next blurs the line between confidence, confusion, and contempt of court.
If you keep giving me those nonsense legal claims, and I've been hearing those for 40 years, man. They're nonsense. They're right up there with the Easter Bunny. I don't mean to insult the Easter Bunny. All right, then we will go to Miss Salaston's case. We will let the state be able to set up. There's very important issues today. Now we were on this. Well, just set the case up, and then it's back to me.
All right. 23B 1593 etched in.
Okay. All right. Ms. Salaston, actually, as I told her earlier today, I had various important legal issues to take up. She was disruptive. After repeated warnings, she was removed from the courtroom. The next important issue, and if Ms. Salaston would quit trying to represent herself, she would have seen this. There was a bench warrant issued for her arrest. She appeared in court on that bench warrant.
Let's pause for context. A bench warrant isn't a casual notice, it's a direct order for arrest when someone fails to appear in court. Here, the judge is making it crystal clear, Miss Salaston ignored legal process for years. Yet, when she finally showed up, she argued like the system owed her an apology. This isn't just about defiance, it's about misunderstanding how bond forfeiture and due process really work. Question for you all, do you think the judge should show patience here, or is it time to draw the line?
Therefore, the bench warrant was resolved. An examination by the record indicates that her prior bond had a judgment forfeiture, which was cured. The sheriff levied, it was satisfied, the bond was never set aside. So if she would have spent more time on paying attention to the legal principles that actually apply, other than this nonsense gibberish, she would have realized it. But she didn't. So now the state has filed a motion to revoke the bond.
Yeah.
And that's the important matter we're on today. So, and she's entitled to notice and due process. So that's why she was brought over today, because those matters are expedited. So let me hear from the state on the state's motion to revoke bond.
And Your Honor, some of the facts you've already put in the record. I will say that on June 21st, 2023 is when the defendant failed to appear in Ellen. The bench warrant was issued. Subsequently, October 20th, 2023, a bond forfeiture was granted. We would submit to the court that basically for 2 years, the defendant evaded the bench warrant.
Here's where the plot thickens, a new arrest by the Georgia State Patrol. Obstruction, driving on a suspended license, improper use of a tag, the same behavior she was already on bond for. That's a legal red flag. Judges consider patterns of behavior, and this one screams repeat risk. It's not about punishment, it's about trust. If she couldn't follow bond terms once, can the court trust her again?
And it looks like September 16th, 2025, the defendant was arrested by Georgia State Patrol And that was for new offenses of obstruction, distracted driving, suspended license, and improper use of intent. The state
arrest made.
that was September 16th, 2025.
Right, so after the time she failed to appear in the court, did she have any other arrests other than this traffic theft?
Not that I'm aware of.
Okay.
And so it wasn't until this arrest by Georgia State Patrol that they discovered the benchmark was outstanding. So we would submit to the court that based on the defendant's own statements in court and her filings,
And there it is, the classic courtroom curveball. I don't recognize the court's authority. This argument often comes from self-proclaimed sovereign citizens, people who believe standard laws don't apply to them. The problem? Courts have consistently ruled otherwise. It's like walking into a chess match and claiming you're playing checkers. It doesn't work that way. What do you think, is this conviction or delusion?
She does not recognize this court's authority. She does not believe this court has any personal jurisdiction over her. And we would submit that any bond condition, she would just ignore. And she does pose a flight risk. Secondly, we would submit to the court that when she was arrested, she basically committed several offenses, which she was out on bond for, with the exception of the fleeing and attempting to elude and the possession of the marijuana. The remaining counts are virtually identical to the counts that she was arrested for: distracted driving, no license, no license plate, obstruction of police. And so we would argue that she violated the conditions of her bond, and she does pose a danger to the community.
Okay. Is she out on probation or parole on any prior offense?
I don't believe so.
Okay. And when she was arrested, did she give a new address?
No, I believe she gave the same address as the arrest.
Which was what?
Yep. Thanks.
Yeah.
The address I'm showing is 2214 Upward Falls Avenue, Latham.
Falls?
Yes. POPLAR. And the zip code is 30058.
Okay. Now, Ms. Salaston, that is the issue before me, is revoking or modifying your bond. If you will, I'll give you an opportunity to be heard in the courtroom if you will come in and get to the point of that. If you keep giving me
And the judge has had enough. Comparing her legal theories to the Easter Bunny? That's courtroom sarcasm at its finest. This moment isn't just comedic, it's revealing. Judges don't like being mocked, but they dislike legal gibberish even more. Behind the humor, there's frustration. This court has tried again and again to help her, and she's refusing to play by the rules.
You keep giving me those nonsense legal claims, and I've been hearing those for 40 years, man. They're nonsense. They're right up there with the Easter Bunny. I don't mean to insult the Easter Bunny. So you want to come out, I'm glad to hear for you. It's an important legal issue. But if you would have quit trying to represent yourself, you would have recognized that you could have posted bond, reposted bond. But you're more concerned with the nonsense than really what applies. And that is to your detriment. But you have a right to make bad decisions. Thus far, you've exercised them. All right, let's see if she wants to come out and be heard on the issue of revoking her bond. If she complies and she does what she's supposed to, I'm glad to hear her out. If she becomes once again disruptive, she will be removed.
Judge, she's saying that she won't have to come out, so I will bring her to you in person.
Okay, so she says she won't come out of the holding cell. Well, that won't last very long.
No, she will. She wants to come out.
Okay, well, if she'll come out, I'm glad to hear it's important.
Yes, sir.
So let's see whether or not she will comply this time.
Yeah. So it's in.
Got it.
Is it?
No, it's not. He had to get.
All right, Salaston is with us. Ma'am, the issue is revoking your bond. State is contending that your bond should be revoked. You don't agree with any authority of the court, and you've been missing for 2 years. So, I'm glad to hear from you concerning what you want to tell me. Now, typically bond is based on whether you're a flight risk. So that's a big hurdle. Been gone. The second one is whether you're a threat or danger to the community. The third is whether or not you're a risk of committing future felony offenses. I've not heard that since you originally posted bond that she had any felony arrests. Is that correct?
Correct.
It's likely that you would pass that criteria. I gotta make all 4. Now, the last one is whether or not you would intimidate witnesses or obstruct justice. I think all the witnesses in this case are wrong.
Yes.
So the likelihood of your intimidating them is just about 0. So the main issues for my reconsideration of your bond is number 1, you're a flight risk. Number 2, whether or not you're a threat or danger to any person in the community. I find that you qualify to the other 2 factors. So what would you like to tell me, if anything, concerning whether or not you should be once again, you should leave your bond where it is right now, which I think was, what was it, 20-some thousand? 30,000. Or I should just strike it. So I'm ready to hear from you if you will get to the lawful point.
Right, I would like to make my statements without interruptions, because if I don't have the right to be heard, then we might as well just.
And you have a right to be heard on those issues, because that's the matter
Right.
right now.
Okay.
If you don't want to talk about those issues, then that concludes this part of the hearing. The other part I've got that I still haven't been able to get through is your Ferretta hearing. They're not gift counsel. You've already missed a huge legal issue on the ability to post bond. And what a bench warrant does after you appear in court. So you're not doing well on your own.
Well,
Do you wish to respond to the bond criteria or not?
Now
Well,
this is where things get complicated. Ms. Salaston argues her bond is excessive and unconstitutional, citing Article 1 and the 8th Amendment. But here's the catch, those protections exist only if you follow proper legal procedure. Courts can absolutely require bond if they believe you're a flight risk. Her insistence on misreading these rights turns what could have been a valid appeal into a dead-end argument. What do you think? Is she fighting for her freedom or fighting the wrong battle?
well, first, the bond is excessive and I'm not supposed to have to be compelled to pay any costs until a conviction on a felony on a final trial. So that is my 17th guaranteed protection under the Article 1, Section 1, paragraph 17 of the Constitution for Georgia. And Article 9 of the Constitution for the United States, which you have an oath to, states that y'all are not supposed to deny or disparage any of my inherent rights that are reserved to me. I have reserved all human rights, natural rights, consanguinity rights, birth rights, constitutional protected rights, and treaty protected rights. And they have been denied and disparaged as if they don't exist. Those are my retaining rights. So I'm trying to understand, what are we doing? What am I supposed to do? What is my way out? I'm constantly feeling like you guys are usurping my rights. I don't even know who this man is, and he's bearing false witness against me. He's got a story that he has just finagled out of anywhere. I don't even know the people on this whole case. I don't know anybody, but I'm sitting here being again accused and not presumed innocent. I'm sitting in chains in a inhumane living conditions. I've never experienced this. I don't have a record. This type of thing is for someone who is actually somebody who is a criminal. I'm not a criminal. I am innocent. And I keep trying to tell you guys my status and my rights.
I have given you your time for a little bit of your talking about the issues that don't apply to God. Now we're back on.
I did give you Article.
The two bond conditions, yes or no?
I gave you Article 1, Section 1, paragraph 17. I'm not to be compelled to pay any bond, anything, until conviction on a final trial. And I should, Amendment 8, I should not be held under false imprisonment, under cruel and unusual punishment, under any bail. That's the Constitution. And is that not correct, sir?
No, you aren't. Just something else you're wrong about. But anyway, ma'am, I'm once again sad.
I can adjust this comments and opinions posted on the record.
This is where I'll have you removed, because right now.
You might as well.
This is the breaking point. The judge, after giving her every chance to comply, finally revokes her bond. His words sting: you won't have to pay anything because you won't have anything to pay. That's not cruelty, it's legal finality. When defendants refuse to recognize authority, they lose the very protections they're fighting for. It's a cautionary tale. Courtroom sovereignty doesn't override judicial patience.
Well, that's fine. I don't care.
That's fine, but ma'am, you're clearly not going to respond to that based on the arguments before me and the non-response by the defendant. I find that the state has met their burden to revoke bond. So I guess in part you're having it granted. You won't have to pay anything because you're not going to have anything to pay.
That's fine.
So
well, it's not for me because I'm not. I'm here with the defendant.
Take care, ma'am.
Under be correct.
Make different decisions.
So there it is. Miss Salaston's courtroom saga ends with her bond revoked and her legal theories dismissed. From sovereign arguments to self-representation gone wrong, this case shows the razor's edge between confidence and contempt. The lesson? Knowledge of the law protects you, misunderstanding it traps you. What's your verdict? Was the judge too harsh or perfectly justified? Let us know in the comments, and if you found this case as shocking as we did, hit that like button, share this video, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. See you next time on Channel Name, where we bring the courtroom to you.